Before the sentence was over, Marcus was already doing something with his hands, not fidgeting, working. He had found a way to volunteer at the pediatric ward of the same hospital system that had, 8 months earlier, had him removed from the premises by security. He was reading to kids on Tuesday afternoons. That is what I learned. That is what I want to tell you about. Not the removal, not the security guard, not even the ruling I made, which you will hear about in full. I want to start there, with a Tuesday afternoon, a children's ward, a man reading out loud to kids who did not know his name, because that is where this case actually ended. I want to tell you how we got there. Subscribe before I keep going. Not because what I am about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications, then let me continue. My name does not matter for the purposes of this video. What matters is that I was on the bench. I have been on the bench long enough to know the difference between a case that teaches you something and a case that reminds you of something you already knew and had started to let go of. This was the second kind. This case did not teach me that human beings are capable of more than their worst moments. I already knew that. What it did was force me to act on that knowledge in a way that was harder than it sounds, and then to watch what happened when I did. That is what I want to pass along. Marcus Ellison was 44 years old when he walked into my courtroom. He is a black man, medium height, the kind of quiet that is not shyness but attention. He walked in carrying a folder, not a lawyer's folder, his own folder with things he had printed out himself and organized in plastic sleeves. I noticed the folder before I noticed anything else about him. There is something about a person who prepares in their own way, not the way the system asks them to prepare, but in whatever way they believe they will be understood. That tells you something true before a single word is spoken. The folder told me he had thought about this, not just about what to say, about what mattered and how to show it. He sat down, put the folder on the table in front of him, and folded his hands on top of it. He did not look up at me right away. He was looking at the folder, 4 to 7 seconds. Then he looked up. I have been on this bench for 19 years. I know the difference between a person who looks at a judge to see if they are going to be believed and a person who looks at a judge to see if they are going to be heard. Marcus was looking for the second thing. I decided in that moment to give it to him. The complainant in this case was Patricia Nguyen, the hospital administrator who had signed off on the removal. She was 51 years old, and she had been doing her job for 23 years, and she had done nothing wrong according to hospital protocol. I want to be precise about that. Patricia Nguyen followed every rule she was given. She was not a villain. She was not even wrong exactly in the technical sense. What she was, and what she told me herself, with a directness I did not expect, was uncertain. She said in her statement, "I have replayed that night more than I thought I would." That sentence did more work in my courtroom than most formal arguments. She did not say she regretted it. She said she had replayed it. There is a difference. Regret is a conclusion. Replaying is a question still being held open. Patricia Nguyen came into my courtroom holding that question open. That is an unusual thing for a complainant to do, and I gave it the weight it deserved. Now let me take you back to the night of March 14th, 2023. It was 11:47 in the evening when Marcus Ellison arrived at Mercy General Hospital in Atlanta, Georgia. His daughter, Camille, was 17 years old and had been admitted 6 hours earlier following a serious car accident. She was in the ICU. She was stable but unconscious. Marcus had been in a custody dispute with his former wife for 3 years, and his visitation rights at that time were limited by a civil order that had not been updated to include medical emergency provisions. A security guard named Theodore Briggs, who was doing his job, I want that on record, informed Marcus at 11:51 that he was not listed as an authorized contact and would need to leave. Marcus said, "She is my daughter and she does not know I am here." He said it quietly. Theodore Briggs confirmed in testimony that Marcus was not shouting. Marcus did not move from the door. He stood there for 6 minutes before Theodore Briggs called for backup. 2 additional security officers arrived, and Marcus was removed from the building. He did not resist. He did not fight. He stood outside the hospital in 38-degree weather for 2 hours and 20 minutes before his attorney reached him by phone and began the process that eventually brought us to my courtroom. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. The charge that brought Marcus into my courtroom was technically a civil harassment filing, a pattern of contact claim arising from his return to the hospital the following morning and his attempts to reach the ICU nurses' station by phone 17 times in a 4-hour period. The hospital had also filed for a no-contact order. That is what was in front of me, not the original removal. The legal question on my desk was whether the subsequent contact attempts constituted harassment under Georgia statute. But here is the thing about legal questions. They arrive inside human stories, and the human story is always larger than the legal question. My job is to answer the legal question. My job is also to understand what I am answering it inside of. I had both things in front of me, and I was not willing to let go of either one. The procedural tool that mattered most in this case was something called equitable construction, a doctrine that allows a judge to interpret the specific application of a statute in light of the particular human circumstances surrounding a case, when strict application would produce a result that the legislature could not reasonably have intended. It is not a loophole. It is not a workaround. It is a recognition built into the law itself that statutes are written for categories, and human beings do not live in categories. They live in specific rooms on specific nights. I had the authority to apply equitable construction here. I used it, and I want to explain exactly what that meant in practice. What it meant was this: I could consider the fact that Marcus's contact attempts were not directed at Patricia Nguyen personally. They were directed at information about his daughter. The harassment statute was written to protect individuals from unwanted personal contact. His calls to the nurse's station were not personal contact with a named individual. They were a father trying to find out if his child was alive. Those are not the same thing. Equitable construction allowed me to hold that distinction and act on it. I did. Marcus walked into my courtroom on the morning of October 7, 2023 at 9:15. I watched him come through the door. He was wearing a dark blue suit that fit him correctly and a tie that was the color of old copper. He walked at a medium pace, not fast, not slow. His eyes went to the gallery first, then to his attorney, then to the table. He did not look at me immediately. He sat down and opened his folder and did not look at me until the proceedings formally began. What I noticed from the bench, and I do not think anyone else in that room noticed this, was that he had a small photograph paper clipped to the inside cover of the folder. I could not see the photograph from where I sat, but I could see that it was there. I did not know then what it was a photograph of. I know now. I will tell you when we get there. Patricia Nguyen came in at 9:18 with her attorney. She sat on the complainant's side, but she chose a chair that was slightly angled, not directly across from Marcus, but not turned away from him either. I have been watching people choose their seats in courtrooms for 19 years. Where a person sits tells you something about what they want the room to know about how they feel. Patricia Nguyen's chair said, "I am here, but I am not certain of everything I am here for." That is not a criticism of her. That is a person in the middle of a question they have not finished answering. I respected it then and I respect it now. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. Turn 1 came on the second day of proceedings during character witness testimony. A woman named Dolores Reyes took the stand. She was 63 years old and she had been Marcus's neighbor for 11 years. She was not a dramatic witness. She did not use large words. She said this: every Tuesday and Thursday, no matter what was going on in his life, he was at Camille's school for pickup. He never asked anyone to do that for him. He just did it. She said it the way you say something that does not feel like testimony, because to you it is just the truth. The room did not react. No one made a sound. But I wrote it down, not because it was legally significant, because it was the first time in this case that I understood what Marcus's stability looked like from the outside, not the loss, the ordinary, continuous, reliable showing up, the Tuesday and Thursday of a life. That was turn one. He became a person to me in that moment, not a case number, not a pattern of contact, not a father in a custody dispute. A man who showed up on Tuesdays and Thursdays. Turn two came on the third day. It came from inside the folder. Marcus had prepared a document, organized himself in plastic sleeves, that contained Camille's school attendance records, her soccer team schedules going back 2 years, 7 letters from her coaches and teachers, and 1 from her school counselor, and a photograph. The photograph I had seen paper-clipped to the inside cover. It was a picture of Marcus and Camille at her 15th birthday. They were standing at the edge of a lake somewhere. She was laughing at something off camera. He was looking at her. Not at the camera. At her. The document was admitted into evidence over the hospital's objection that it was emotionally manipulative. I overruled that objection. Documents that contain true things are not manipulative, they are informative. The truth in this document was that Marcus Ellison had been a continuous, specific, present parent. The charge in front of me was whether he had harassed a hospital by trying to reach his unconscious child. Those two things did not fit in the same sentence. That was turn two. The evidence showed me not only who he was, but what the charge was actually asking me to do, and I was no longer willing to do it. I want to place something here before I get to the sentencing. I want to tell you about a Tuesday afternoon in the fall of 1987. I was 11 years old and my father was in a hospital in Richmond, Virginia, following a cardiac event. My mother drove us there and was told at the desk that visiting hours had ended at 7 and it was now 7:20 and we could not go up. My mother stood very still and then she said, "I need you to understand that I am not asking for a favor. I am asking you to think about what you are doing." They let us go up. I do not know why they did. Maybe the nurse saw something in her. Maybe it was the specific quietness of it. I sat beside my father's bed for 40 minutes that night. He recovered fully. He lived until 2011. But I have thought about that desk and that nurse and my mother's voice many times in 19 years on the bench. I thought about it again when I read Marcus Ellison's file. I did not tell anyone that. I am telling you now. Subscribe. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. Turn 3 arrived at sentencing on the morning of November 2nd, 2023. The room was quiet in the way rooms get when people believe something is about to happen but are not certain what it will be. Marcus was sitting with his hands flat on the table, not on the folder this time, just on the table, palms down. His attorney, a woman named Sandra Okafor, who had argued this case with the specific combination of rigor and personal conviction that I find rare and genuinely useful, was sitting beside him. Patricia Nguyen was in the front row of the gallery. Her attorney had advised her that the no-contact order would likely be denied, and she had decided to stay anyway. I noticed that she had moved slightly forward in her seat, not tense, attentive. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I denied the no-contact order. Then I ruled that the contact attempts did not meet the threshold for civil harassment under Georgia statute, applying equitable construction to the specific circumstances of the case. Marcus Ellison was not ordered to pay fines or serve any punitive measure, but I did not stop there, because stopping there would have left everyone in the room with nothing except a ruling, and a ruling without structure is just a moment. I wanted to give them more than a moment. I said the following from the bench. I am ordering you, Mr. Ellison, to complete a 12-hour course in family medical advocacy law, specifically the provisions covering parental rights during medical emergencies, within 90 days of today. Not because you did anything wrong, because what happened to you on March 14th happened in part because you did not know what tools the law had made available to you. That is not a punishment, it is a preparation. I am also ordering both parties to participate in a single joint mediation session to be completed within 60 days, with the purpose of establishing a written medical emergency protocol agreed upon by all parties that can be submitted to the civil court managing the custody matter. I am doing this because the civil order that governed your access on March 14th had a gap in it, and that gap hurts someone. Gaps in orders that affect children should not remain gaps. And there is one more thing. I am asking, not ordering, asking, that you consider offering your time in a volunteer capacity to a hospital or healthcare facility in a role that connects you to other families navigating what you navigated on that night. I am asking it because the evidence in this case showed me a person with a specific kind of patience and presence that is genuinely useful to people in crisis. Whether you do it or not is your choice. But I want you to know that I saw it in you, and I believe it is worth putting somewhere. The condition for early completion of the mediation requirement is this. If the joint protocol is submitted to the civil court within 30 days rather than 60, the advocacy course requirement will be reduced to 6 hours, to be completed through self-directed online study rather than structured attendance. That is not a loophole. That is my way of saying that if both parties can move quickly enough to protect this child, the system should move with them. I want to say something to you directly, Mr. Ellison, before we close. What you did on March 14th, standing outside that hospital in 38-degree weather for 2 hours and 20 minutes, was not a crime. It was a father doing the only thing he could think of to stay close to his child. What happened to you inside that building before that happened to you, being removed by security while your daughter was unconscious in an ICU, that was not a crime either. It was a gap between a rule and a reality. And gaps like that are painful in ways that legal findings cannot fully account for. I want to name that plainly. I want Patricia Nguyen to hear me name it plainly. She did not cause that gap. The system produced it. She enforced it. There is a difference, and I am holding the difference clearly. To the people in this room who have watched this process, your presence here mattered. The way this case was brought and argued said something about what everyone in this room actually wanted, which was not punishment. What everyone in this room wanted was a path forward for a child who deserves to have both of her parents able to get to her when she needs them. I'm going to do everything within my authority today to give her that. Mr. Ellison, Marcus, I wrote down something you said on the second day of testimony. You said, I just needed her to know I was trying. I wrote it down. Not because I needed to remember it, because I wanted to. Subscribe. I am about to tell you what happened after the sentence, whether this person did what I believed he would do. Subscribe so you are here for that part. It is the part I care about most. After I spoke, the room did not break into sound. It went through a kind of stillness first. I was watching from the bench. Patricia Nguyen put her hand over her mouth, not crying, at least not what I could see from where I sat. Just stillness, and her hand over her mouth, and her eyes closed for maybe 3 seconds. Then she opened them. Then Sandra Okafor touched Marcus on the arm, once, briefly, and he nodded. I watched that nod. It was the nod of a person receiving something they had decided not to expect. Before I stood up, I poured myself a glass of water from the pitcher on the bench and drank it. The water was room temperature and slightly stale from sitting. It tasted completely ordinary. And on that particular morning, that ordinary taste felt like the right ending to what had just happened. On January 14, 2024, 73 days after the ruling, I received a copy of the joint medical protocol, filed with the civil court and signed by both parties. It had been completed in 47 days. Marcus Ellison completed his advocacy course at 6 hours through self-directed study, as the early completion provision allowed. On February 6, 2024, Camille Ellison was discharged from a follow-up neurology appointment. She had recovered from the accident with no permanent deficits, and Marcus was listed as an authorized emergency contact in her updated medical file. I did not find that out officially. I heard it through Sandra Okafor, who called my clerk's office simply to report that the protocol was being honored. I asked my clerk to pass along that I was glad. No appeal was filed by either party. I noted that when the window closed. I will not pretend it meant nothing to me. It meant that everyone in that room had concluded that what happened there was enough. I have come to believe that precision is not the opposite of compassion. I have come to believe it is the form compassion takes when compassion is serious. It would have been easy in this case to do either of two simple things: deny everything and leave Marcus with a no-contact order that protected the hospital's legal position and left his daughter effectively unreachable to him in a crisis, or make a broad, sympathetic ruling with no structure, full of warmth and short on requirements, that would have resolved the courtroom moment without building anything that would last. I did neither. I built something. Building something requires you to know the person you are building it for. This case required me to know Marcus Ellison well enough to design obligations that fit his actual life. Not the worst version of his life, not the easiest version, but the real one. That is the hardest thing this work asks of me. It is also the thing that makes the work worth doing. What this case gave back to me, not as a judge but as a person, was the specific confidence that comes from having done the harder thing and watched it hold. To anyone watching this who has been where Marcus was, who made a real mistake or who found themselves on the wrong side of a rule at the worst possible moment, and who has been carrying the question of whether there is a path forward, what I look for from this bench is not perfection. I look for the quality of continuous showing up, Tuesdays and Thursdays regardless of circumstances. I look for the presence that Dolores Reyes described. Not dramatic, not performed, just reliable. If you have that in you and you are willing to let it be seen, that is something a judge can work with. What you can do with that information is be that person consistently and then trust the room to recognize it. Trust, but also show. Bring the folder. Organize what matters to you in whatever way you believe it will be understood. Come prepared to be seen. To anyone who has been in Patricia Nguyen's position, who was asked in the middle of their own uncertain feelings about a situation to consider something other than maximum protection for themselves, I want to tell you what I have witnessed from this bench when a person in your position makes room for something other than distance. I have watched it do something for them that I cannot fully explain from the outside, but that I have seen enough times to report honestly. It seems to lift a specific weight. Not the weight of what happened. That stays. But the weight of being the person who sealed the door. That one seems to move. I am not telling you what to want. I am telling you what I have observed from the bench when someone wanted something more complicated than the easiest answer. I have watched it look from where I sit like a kind of freedom. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. On a Tuesday afternoon, Marcus Ellison sat in a chair beside a hospital bed in the pediatric ward of a different facility in Atlanta and read a book out loud to a 7-year-old who had never met him. That is what I started with. That is where I end. Not because it is a perfect image, because it is a true one. A man who stood outside a hospital in the cold because he needed his daughter to know he was trying, sitting inside a different hospital reading to someone else's child. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. The comments on these videos have become something I did not expect. A room where people who understand that justice and humanity are not opposites come to talk to each other. Come be part of that room.